When I think about what sorts of initial cases I want to file, I think about what jurisdiction I want to file these sorts of cases in. For good or ill, we have 50 states, the District of Columbia. We have a federal court, federal system. So there's at least 52 separate jurisdictions in the U.S. So if we want to begin filing a lawsuit in the U.S., then we have a choice of 52 high courts. We can pick and choose and try to determine where are we going to get the best kind of reception. In my mind, where are we going to find the principal judges who will listen to our arguments in principle, which I think are very powerful, and will be persuaded by them. Because if we go in front of a Supreme Court of some state and they're all formal judges who all they care about is what happened in the past, we're going to lose. So I'm in the process now of trying to look through the 50 states and say, what high courts are there that are not so much backwards-looking courts, but are forward-looking courts who will be receptive to an argument from principle. And it's not black and white. It's not the easiest thing to do, but I think there are some courts who tend to look backwards or who tend to be followers. There are other courts who tend to look forwards and tend to be leaders. And so we're trying to identify them, and those are the courts in which we think will have the best shot. So in that way, we can shop for judges. We're shopping for jurisdictions, really. The kind of judge that anybody wants to go in front of when they're trying to extend the common law or change the law is not a formal judge who looks backwards. Because if I go into a court and of a judge who's looking backwards, and I say, hey, chimpanzees should have a certain kind of right to bodily liberty, and the judge then goes to the law library, opens up the book and says, well, chimpanzees never have had that kind of a right, and they're not going to have it now. Go to Parliament or go to Congress or somewhere. So you want to stay away then from formalistic judges. So you want to go in front of substantive judges, judges who are looking forward and who want to make rulings that they think will be more in harmony with scientific fact, with changes in mores, changes in public opinion. And of the two, policy judges who are interested in what's good, as opposed to principal judges who care about what is right, I think you want to tend to go in front of principal judges who care about what is right. And you're making arguments that say chimpanzees shouldn't be able to be killed because it's wrong, and this is why it's wrong. And so those I think are the judges that I would tend to want to zero in on, ones who are principal judges, and they're all over the place. Our most famous judges are principal judges, the ones who say, this is right, and the law the law needs to be right. The judges who say, well, this is how it's been done for 800 years, it's how it's going to be done now, are not the famous judges of our world. It's the ones who changed something because it had gone out of fashion, it had gone out of date, it had become archaic. And so you want to go in front of those judges. In fact, I ended up writing an entire book, Though the Heavens May Fall, about how it is that one slave, James Somerset, was able to file a lawsuit in the Court of King's Bench in England in 1772 and emerged not a slave but a free man. And what kind of arguments did his lawyers make? What kind of judge was Lord Mansfield, who was the judge? Was he the kind of judge who would simply look in the book and say, oh my goodness, we've always had slavery, so you're going to be a slave? Or would he pay attention to arguments about principle, what's right or wrong? And it turns out he was one of the great principal judges, and indeed that's exactly what he did. And he said, you are a free man. Because slavery is so odious that the common law will not support it. I mean, that is the classic statement of a principal judge.